Anin, Bojo. The process for appointing a guardian for your minor children and managing estates for minors can vary by jurisdiction. So, depending on where you live, the guardian that you appoint in your will may be considered temporary or permanent. Let's start off by defining what is a guardian and what is a trustee. A guardian is a person who has been appointed to have legal responsibility to care for someone who is unable to manage their own affairs. For example, children or minors, or certain persons with a disability or illness who are unable to make their own decisions. A trustee is a person who's been appointed to administer a trust. A trust preserves and manages the assets for the benefit of the beneficiary. They are responsible for acting in the best interests of the beneficiaries of an estate. The creator of a trust can state that the beneficiaries receive assets over time upon their death, or when the beneficiaries reach a certain age. Trustees have the responsibility of managing the assets with the best interests of the beneficiaries in mind. Trustees owe the beneficiaries a fiduciary duty. As part of this duty, trustees have a legal obligation to act in the best interest of the beneficiaries at all times. In summary, a guardian takes responsibility for any minor or disabled child and makes living arrangements for them, and a trustee manages any funds set aside in a trust fund. A guardian is the person who has the power over a person and estate of a child. The power is broad and includes where and how the child will live, what activities they will participate in, and how their estate will be managed. There are limits to this power, but as long as the guardian acts honestly and in the best interest of the child, they may make the most decisions about the child without interference. As a parent, you have legal authority and responsibility to care for your children as their guardian during their lifetime. If a minor child has two parents, they are both usually considered legal guardians. If one legal guardian dies, then the surviving guardian would be the children's sole guardian. However, if there is no surviving guardian, and the parent who just passed away had a legally binding will, the guardian of the children will be the person appointed in the will. What happens to your children after you die will depend if you have a guardian appointed in your will or not, and if there's a surviving parent. If there is no will or no guardian appointed in the will, then in most cases, the surviving parent, who is also a guardian, will continue to be the guardian of the child. If the surviving parent is not already a guardian, they do not automatically become one upon the death of the other parent, unless the surviving parent has been appointed guardian by the will or by the other parent. A person must still apply to be appointed as a guardian. Where there is no surviving parent and no guardian has been appointed, the court may hear applications to appoint a guardian. For children who are over the age of 12, they must consent in writing to the appointment unless the court is convinced that it's necessary in the best interests of the child. A number of issues may arise if you don't have a will and therefore haven't named a guardian for your minor child. For instance, the court and your family won't have any knowledge of your wishes as the parent or whether you would have wanted a particular person to be your child's legal guardian. Another concern is that more than one person could apply to the court to be named guardian because they each think they are the best fit for the role. This can create conflicts within families and additional stresses on the family. If you have a will and have appointed a guardian for your child in the will, this will let the court know who you think would be the best person to have legal responsibility for your child. Parents and legal guardians can appoint a guardian in their will in case of death. It's important to choose someone who you trust when making this decision, as they will be responsible for making choices about the activities that your child participates in, what medical treatments they receive, where they go to school, and where they live. It's also important to note that even guardians appointed in a will still may need to go through a court process to gain custody of minors. Appointing somebody in a will does not automatically guarantee that they will become guardian. Choosing a guardian for your child requires a lot of consideration. Make sure that the person that you're choosing is willing to take on that responsibility and is somebody that you trust with the care of your child. Some things to consider before identifying a guardian in your will is this somebody that your child trusts? Does your child have a close relationship with this person? Does this person have the want and ability to care for your child? For example, are they emotionally prepared, financially stable, or physically capable? Do you share the same values of this person? Where does this person live, and is your child prepared to move if needed? Does this person already have children, and do they get along with your child? Are they willing to integrate your child into their family? You'll also want to consider how many people you are appointing. A parent can name more than one guardian in their will. For example, a couple can be named, such as grandparents, in-laws, or friends. Naming co-guardians can create challenges when there's a breakdown of the co-guardian's relationship. For example, circumstances can change and co-guardians can separate. To avoid conflict, it may be a best practice to only name one guardian in the will, such as a sibling that you want to take guardianship over your child. It's also important to remember that although a guardian may be appointed by the deceased in their will, other family members or next of kin not named may also apply to become a guardian for the child. The court may also remove a guardian appointed in the will if it's in the best interest of the child. You may also want to consider that there's a chance that the guardian you've selected is unable or unwilling to take on this role. So it's wise to name an alternative guardian in your will. In situations where the named guardian cannot accept the responsibility, you have a backup plan to name an alternative guardian. A guardian isn't the only thing that can be appointed in a will. Trustees can also be appointed to manage the estates of minors. However, if an Indigenous person dies without a will while living on reserve, it's the Indian Act that determines how the estate of minors will be managed. Under Section 52 of the Indian Act, Indigenous Services Canada may help manage and appoint guardians for estates of minors registered under the Act who usually live on reserve. This includes minors who are entitled to be registered under the Act, minors whose names are on a First Nation membership list or could be added to a First Nation membership list, and minors whose parents who are registered under the Act. Depending on where you live, the definition of a minor may be different. Different territories have different regulations. In Ontario, anyone under the age of 18 is considered a minor. A minor can have an estate, such as property or possessions, that have been passed on from a deceased person. Usually a parent or guardian is responsible for the management of the estate because the minor is not of legal age to do so. A trustee may also be named and appointed in situations where there is a will to manage the inheritance of a minor. IS can only help administer the estates of minors in rare circumstances, and their ability to help manage the estates is outlined in Section 52 of the Indian Act and considered discretionary. Once a child turns 18 or is no longer considered a minor, they are entitled to the remaining inheritance in a lump sum payment. In exceptional circumstances, the guardian of a child or the council of a band can request to Indigenous Services Canada in writing that the remaining inheritance be paid out in installments for up to 3 years after turning 18 if it's in the best interest of the individual. Please note that this request does need to be completed in writing to Indigenous Services Canada before the child becomes age of majority. Thank you.